Hi, this is Steve Carlson again. This is a summary of the argument I will present at a court hearing on an election contest against Al Franken tomorrow. Al is slick. With $25 million he raised for his Senate seat, he has paid some slick lawyers and essentially bought the Minnesota governor too. During this contest, Al tried to take advantage of some loopholes in election law. And now he's trying to drive his truck through the contest. This is the same thing he started to do when he announced about the time of the state fair in August 2014 that he would exclude the Independence Party from all general election debates, but have 3 with the Republican. At that time, I realized my mission in life for the 2014 Senate election from Minnesota, for which I was the Independence Party nominee, is to fight this violation of the civil rights of mine, of the Independence Party and independent voters of Minnesota who had elected me in a statewide primary. After litigating at the FCC Political Department, at the Minnesota Supreme Court and the U.S. Supreme Court during the general election, and excluded by the big man Al Franken from all public broadcasts of any debates, and Al and Mike refused to show up at an Asian debate or a Hispanic debate that had been scheduled, I visited the Minnesota Canvassing Board, and I told them in a letter I delivered to them that Minnesota courts had failed to allow the U.S. Congress to have the ability to make an independent judgment on matters of serious, material, and deliberate violations of Minnesota election law by Franken, by his Democratic Secretary of State, Mark Ritchie, and Minnesota courts. And I told them I would bring this to the U.S. Supreme Court. In 2012, the Minnesota Supreme Court refused to allow this contest to go forward when a number of the same unconstitutional and corrupt practices which called into question Betty McCollum's right to the 4th congressional district seat in the U.S. House of Representatives also occurred. And these are ongoing and need to be addressed so we can have free and fair elections. Now, the facts are on the record. But this year, because the name of the Minnesota Supreme Court is directly in the law written by the legislature, prescribed by the legislature, as opposed to a state district court, which Betty's contest would have dealt with, they were forced to allow this contest to be filed under Minnesota Statute 209-12. Then the game started. A panel appointed by Lori Gildea, elected by you, the voters, for some reason, as Chief Justice of the Minnesota Supreme Court, refused to allow evidence of this violation of Minnesota election law to be discovered, collected, or forwarded to the U.S. Senate. Really? Well, yes, because as Al's cases for tomorrow's hearing show, there are a lot of loopholes. I would even say huge fissures and crevices in election law, which call into question the firm foundation of our dreams of a democratic form of government. So Al's strategy has been to team up with his Democratic brothers Mark Ritchie and Mark Dayton and to bring to the U.S. Senate an unlawful, wrongfully obtained election certificate while this contest was yet pending, December 19th, 2014. Really? Then he quick got it up to the Senate before I even knew what this panel had done. And now it's a fait accompli. Imagine Stuart Little on Saturday Night Live going, nah, 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 I got this paper illegally and there's not a thing you can do about it. Well, I filed this motion to void the judgment, allowing him to do this in violation of Minnesota election law. Al's real good at this. What do they say in that King Kong movie? He's real good at crapping the crappers. And that's what tomorrow's hearing is about. Al says his motion is, or my motion, to void this is sound and fury signifying nothing because Al's already been sworn in, unquote. Really? I mean, this guy's a senator, put in by the same courts and lawyers in 2008. And as such, he was one of the 100 judges, that is to say, the members of the Senate, which were the sole judges of the contest whether or not to seat himself. And he somehow got Governor Dayton to sign and seal a certificate that says there were no contests pending when he got this certificate he sent to the Secretary of the United States Senate. Of course, that was false, and we all knew that, but it's a game, because now Al submitted these 10 cases on election law, and what they say, he says, is that once he's been seated, rightly or wrongly, there's nothing anybody can do about it. Well, I looked over these cases. I just put up a video today on the case where the Democrats in Texas in 1977 used the same tactic against Ron Paul in the 22nd Congressional District race down there against Gamage. I looked at the case of Walter Nixon and a House case from Ohio and put those up yesterday. And here's a summary covering the other 7 cases and kind of tying everything together. Together, what these cases show is that the United States Supreme Court has been very clear and consistent over the years protecting the right of the states to enact a complete congressional election code. In fact, I would say the duty and mandate to the states, and to enforce it. But the Minnesota courts for 2 years, including this panel, have refused to enforce it. And Al, having danced away from any debates, is now dancing away from the contest with his phony piece of paper Mark Dayton gave him. So here's the problem. The guy cheated, he misled the court, misled the governor, and had his friend Lori Swanson frustrate and defeat the laws, Constitution, and precedent of the United States Supreme Court. Now he just wants to shut the contest down. I'm not a lawyer. He's got the Attorney General and 2 Washington, D.C. attorneys and 2 Minneapolis election attorneys, and he's got to prove that this all has to come to a screeching halt immediately. You know, thank you for playing, and he's relying on these 10 cases. Here's what I think these 10 cases say. When you have a sophisticated election contest for congressional races, like Minnesota does, the best I've ever seen in any of these cases, you must follow that election law. If there's a question of Franken's or McCollum's right to office because of serious, material, and deliberate violation of Minnesota election law provisions, then the panel headed by Judge Vandenorth must collect that evidence and forward it all, including a transcript of the proceedings, to the U.S. Senate, along with a valid election certificate. And you can't just send the election certificate when the contest is still pending, because Minnesota law prohibits that. You have to have a trial, collect the evidence, and permit discovery, including things like deposing Al Franken and Mike McFadden, Mark Ritchie, and others having knowledge of these violations. Only then does Minnesota law allow you to issue the election certificate. So under the law, because there were so many hiccups, Al might have been a few days late to Washington, but he would have had this certificate and a bunch of evidence about the questions about his right to office. And if the Senate said, fine, we don't care, he could have been properly seated. That isn't to say it couldn't be reviewed for constitutionality. Now instead, he came down as a judge. He is a judge because he is a member of the U.S. Senate. And he came into this trial and he said, shut it down. Just give me the piece of paper or I'll Al Franken you. And you can talk to Rush Limbaugh or Bill O'Reilly or Ann Coulter about what that's like. He got the Attorney General to team up with him, and he got the phony paper while the election contest was still pending. He got seated with that phony piece of paper. And as a result, as a judge, he blocked fact-finding in the Senate decision. And now he's using these cases to say, just go away, thanks for playing, but the Constitution, Article 1, Section 5, requires that all this be dismissed, with all due respect, of course. But what Al has done, because he couldn't just do it right, is to violate Article 1, Section 5 himself. As these cases say, what is unconstitutional is to frustrate the ability of the U.S. Senate to make an independent decision. And by getting the governor to pretend to the Senate that there was no contest pending and say so under seal, while withholding all the evidence, all the fact-finding, Al abused his power and frustrated the ability of the Senate because they needed to have the evidence that was suppressed. And they unsuspectingly, I suspect, were taken in by the governor's signature and seal that the contest was settled. Now, the difficulty is that, as the U.S. Supreme Court has said consistently, states get a grant of authority under Section 4, not Section 5, but 4 of Article 1 of the Constitution, the one that explains how Congress is constituted, elected and empowered to govern as one of the 3 co-equal branches of the United States of America government. And for some reason, none of the judges or lawyers really follow this grant of authority. Everybody seems to get caught up in this Franken trap because they think they're going to follow their state contest laws. But then someone runs into the Senate or House and gets seated, usually along party lines, and then seeks to dismiss the contest. Do you think this is lawful under the Constitution as it's interpreted by the Supreme Court? I'll tell you. This afternoon I posted a video about Ron Paul and his 1977 contest in a case called Gamage. That's his 1977 opponent versus Compton. That's the Texas judge who was going to allow him to depose Gamage for an election contest about voting irregularities, who ran up to the Democratic House and had them seat him, and then turned around like Al Franken. Nah, nah, nah. You can watch that video. But here I'm going to tell you a little more about what the U.S. Supreme Court said election laws and election contests are about in a case called Smiley versus Holm from 1932. Interestingly, this case was from Minnesota, involving the Minnesota Legislature and a Minnesota governor. They were haggling about redistricting, actually, and the question was whether the governor could veto the election laws they passed. And this was the occasion for Chief Justice Hughes to outline the powers of the states under Article 1, Section 4. He wrote, Article 1, Section 4 of the Constitution of the United States provides, quote, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators, unquote. And he explained, it cannot be doubted that these comprehensive words embrace authority to provide a complete code for congressional elections, not only as to times and places, but in relation to notices, registration, supervision of voting, protection of voters, prevention of fraud and corrupt practices, counting of votes, duties of inspectors and canvassers, and making and publication of election returns. In short, to enact the numerous requirements as to procedure and safeguards which experience shows, like the experience here with Al Franken, are necessary in order to enforce the fundamental right involved. And these requirements would be nugatory if they did not have appropriate sanctions in the definition of offenses and punishments. All this is comprised in the subject of times, places, and manner of holding elections, unquote. It involves lawmaking in its essential features and most important aspect. This view is confirmed, he wrote, by the second clause of Article 1, Section 4, which provides that the Congress may at any time by law make or alter such regulations, with the single exception stated. The phrase such regulations plainly refers to regulations of the same general character that the legislature of the state is authorized to prescribe with respect to congressional elections. In exercising this power, the Congress may supplement these state regulations, or may substitute its own. It may impose additional penalties for the violation of state laws, or provide independent sanctions. It has a general supervisory power over the whole subject. And so now you see how Sections 4 and 5 really fit together. And this is from the Supreme Court Chief Justice. It's never been challenged or overturned. And he says, and actually I say, this is an impressive grant of authority to the Minnesota State Legislature. Clearly, the U.S. Supreme Court told Minnesota in 1932 that the Minnesota Legislature had the power to establish a complete congressional election code, and that includes the Congressional Election Provision 20912, and Congress has the power to supplement the regulations. But Al has to follow them all, and this panel has to follow them all. But he didn't do that. He used his political clout to corrupt the certification process and con the Senate. And Hughes explained, again, that, quote, these requirements would be nugatory if they did not have appropriate sanctions in the definition of offenses and punishments, unquote. Well, one thing is sure, the framers did not want the requirements of the congressional election rules to be nugatory, of no value. And that is why this panel and the Minnesota Supreme Court simply cannot continue to ignore Minnesota's election laws and cherry pick those provisions they like and those they don't. Now, the answer to whether the governor can veto the redistricting of congressional districts passed by the legislature, in case you're wondering, is no. And I would submit that this is very similar to the question, can Mark Dayton ignore the Minnesota election laws and send a phony certificate to the Senate for Al Franken in violation of those laws? The answer is no, he can't do that, and the certificate is null and void. But now what? Has Al just snookered the state, sold the Brooklyn Bridge to Washington? First, let's be clear about the power and scope of the Minnesota Legislature. Hughes writes to explain why the governor can't veto the state election laws for federal office. Quote, the legislature, in districting the state, is not strictly in the discharge of legislative duties as a lawmaking body, acting in its sovereign capacity, but is acting as representative of the people of the state under the power granted by said Article 1, Section 4. When the legislature passes these election laws, the courts are ignoring, I'm saying now, the Minnesota courts are not merely ignoring the legislature and substituting their common law wisdom, because the legislature is acting as the representative, singular, of the people of the state under the power granted by said Article 1, Section 4. And in redistricting, the legislature, said Hughes, quote, merely gives expression as to district lines in aid of the election of certain federal officials, prescribing one of the essential details serving primarily the federal government, and secondly, the people of the state. The legislature is designated as a mere agency to discharge the particular duty. The governor's veto has no relation to such matters. That power pertains under the state constitution exclusively to state affairs. So when we get involved in these federal contests, Mark Dayton has no power except when his seal says that the state law has been followed, it should be able to be believed, and it can't. And Hughes continues, the word legislature has reference to the well-recognized branch of the state government created by the state as one of its three branches for a specific purpose, and when the framers of the federal constitution employed this term, we believe, they made use of it in the ordinary sense with reference to the official body invested with the functions of making laws, the legislative body of the state, and that they did not intend to include the state's chief executive as a part thereof. We would not be justified in construing the term as being used in its enlarged sense as meaning the state or as meaning the lawmaking power of the state, unquote. So, no funny business from the governor. But in a lot of these cases that Franken submits, they did not read Holmes. And in fact, I had to dig it up to look at it. But for those who say, as most of these state Supreme Courts have, that Article 1, Section 5 gives exclusive power for the whole contest to the Congress, I say this. The Constitution also grants authority as a representative of the people of Minnesota acting in aid of certain federal officials, that is to say, as part of the federal government, in this case, part of the Senate. And as I have said, clearly the framers meant to exclude the governor from manipulation of the issuance of the certificate to enforce the election code. Now, these other state cases really do not apply because Minnesota, maybe because they read this great election law power given to the legislature by the Chief Justice of the U.S. Supreme Court in his major national case, has put together a contest provision which helps, aids the Senate in regulating congressional elections to represent this old prairie state, and aids them in gathering any evidence about serious deliberate material violation of the Minnesota election law. And it has to have teeth, as Hughes said, and I ask this panel to continue to carry out this law. The Senate has acted on actions by its member, Judge Al Franken, in violation of Section 5, Section 4 of the Congress Article 1 of the U.S. Constitution. They have the power to expel, to pass laws in aid and supplemental to Minnesota Congressional Election Code, and even to void their own action. I would be in favor of them continuing to seat Al conditionally as they and others investigate these violations, and then address the whole matter so as to strengthen and preserve American democracy and the Congress of the United States. I have to cut this whole presentation down to 30 minutes for tomorrow's court hearing, and then I'll put that up on my website as well. I am running for President of the United States in 2016, seeking to strengthen the role of independent voters across the country to invigorate our Republican form of government and provide more effective and able leadership in the White House and Congress. Thanks for listening.